Good morning, everybody. I'm Jane Fielding and I'm Head of Employment, Labour and Equalities here at Gowling in the UK. I'm very pleased that you can join us for what is the fourth and final webinar in our series of webinars that we've been running over the last couple of weeks to replace our normal in-person mid-year review seminar, bringing you up to speed with developments at the half-year point. Our topic for today is redundancy, and redundancy, of course, like everything else at the moment, in a COVID context. And judging by the 300 or so of you that have registered for the webinar today and the announcements last night in the news about 12,000 redundancies in retail and manufacturing, for example, we are confident it's a very topical subject, if a difficult one. So what we're going to cover is, how do you know you're in a redundancy situation? What is the legal definition of redundancy? If you are in that situation, what processes do you need to follow to make sure that you're compliant with the law and avoiding triggering claims? And then finally, as I said, all of this at the moment is being looked at in a very changed environment potentially. So what, if anything, has changed and needs to be done differently in a post-COVID context, or in an ongoing COVID context perhaps? So our speaker today is one of my fellow partners and friends, Martin Chitty, who has a huge amount of experience of dealing with redundancy situations through various difficult periods in the economy and otherwise. He's going to speak for about 30 minutes and then we'll have some time at the end for questions. We will finish at about 20 to 12, so you can get on with the rest of your day. And just before I hand over to Martin, a couple of housekeeping points, not as many as if we were in person, don't need to do the fire alarm, for example. If you do want to ask a question, then please use the Q&A option at the bottom of your screen. You'll see it's a little Q&A thing. If you press on there and type in your question, I will monitor those as we go through, and we will try and pick up as many as we can at the end, but we can't give any guarantees. If you post your question anonymously, then we won't be able to come back to you because we won't know who to come back to. So if you want a reply, then please do put your name in there and we'll have your contact details. And at the end of the session, you will receive a request for feedback. Please do fill that in. It only takes a couple of minutes and we do read those and take them into account when we're looking at future topics and formats. So as I say, please do fill that in before you log off. So I will hand over to Martin.
Right, good morning everybody. Hello and welcome. It's often said that the period coming out of a recession is actually harder than the recessionary period itself. I think there's some broad parallels. We probably have to accept that we're going into a recession at this point rather than coming out of it, but I think there are some broad parallels with what we now face as employers and business managers as we come out of the lockdown period. And the government's job retention scheme has had the effect of providing a very effective subsidy for, and figures vary, somewhere between 6 and 8 million people in the workforce, and some sectors would have failed already were it not for that level of support. But now as that starts to decline over the next few months, and despite the fact that we've got the facility to bring people back on a part-time basis with some declining level of support, there is a need to act, and we've already started to see that with our clients and in your businesses as well. So some of what I'm going to talk about today, if you like, is a bit of a recap on the theory of redundancy and how it works and what our various obligations are and what we need to be looking at. And some of it is actually informed by work that we're doing at the moment for existing clients. Some of our clients started planning this, as I'm sure you have, at a relatively early stage because they could see that there was going to be a substantive and long-term change in their business needs. It might not just be about short-term reductions in the headcount, but there might be a longer-term structural change in the market as a result of all that has gone on. So I'm going to talk about 2 or 3 basic topics as Jane's described. So what is a redundancy, just to make sure we're all on the same page. It's slightly broader than sometimes people realise. Secondly, we're going to talk about consultation, what that looks like from a collective and individual basis. And then I'm going to try and bring that together in terms of, well, what's very different or different at all about this sort of post-COVID, post-lockdown period. So let's start with the entry-level question, if you like, which is what's a redundancy? And I think here I just want to pick up on the breadth of this, because it will come back as a recurrent theme as we talk this morning. And it is an issue which can cause problems on occasion if we're not wary of it. So the three standard definitions taken from the Employment Rights Act are about place of work, type of work, and the reduced need for work of a particular type. So bringing that into a sharper focus, place of work is that the place at which you work is going to close down. And there's probably no more absolute or clearer way of describing a redundancy situation. So the shop, factory, office, whatever it might be, is simply going to close. And there's certainly quite a lot of that at the moment. We're seeing it in the retail environment, particularly the hospitality sector. Clients have been very clear that they're not going to go back to full opening. In fact, some stores will never reopen. Even John Lewis have suggested that some of their stores may not reopen at all. And that represents a significant structural change. It may be that that was coming anyway, and the period of closure we've had recently and what's been going on with reduced demand in the market has simply brought that to fruition earlier than it might otherwise have happened. So that's the first type. The second type is that a particular strand of work is not going to carry forward. Historically, this was about a particular product line, a particular area of the business is going to cease to operate. So a type of work in which a group of people are employed is not going to be continued within the business going forward. And we might see that in manufacturing in all sorts of environments. And that tends to be, again, relatively straightforward, because if you are engaged in that type of work, clearly your job is redundant. What then happens is a separate issue, and we'll come back to that in terms of alternative work. And the third type historically is reduced need for work of a particular type. So we're still going to do it, and we're still going to do it in the same place, but we're not going to need as many people to do it. And this, in many ways, is the most difficult sort of redundancy in procedural terms, simply because we've got to identify a proportion of the workforce who we no longer need. And for them, it's the equivalent of being told, well, it's not about you, it's about us. We don't need you, we don't want you. You're surplus to requirements. And we've preferred other people over you. And that, in my experience, is the most difficult area to deal with, simply because of the emotional impact of that. If everybody is in the same boat, so everybody on your production line or everybody in your office or shop, factory is losing their job, somehow the impact isn't as great because other people haven't been preferred over you. Management has not chosen to retain them. You've been dumped. Now, the fourth point here is the one I just want to dwell on for a moment, and it's about non-fault based dismissal. But what do I mean by that? Well, actually, it's any termination which isn't down to the conduct or a qualitative issue about the individual. And where it comes into play here, I think, is twofold, and we do need to think about it. One is that if we're dealing with non-fault based dismissals, then, as I'll talk about later, there's an obligation to consult collectively, either with trade unions if you have them, or with elected employee representatives. Why might that be relevant here? Well, non-fault based dismissal is in fact how redundancies are described for collective consultation purposes. And you might get to a position where, as opposed to reducing headcount, let's say from 100 to 75, you simply look to achieve a 25% cost reduction. So you decide to keep everybody in the business, everybody on the boat. You don't want to lose the skills you've built up over a long period of years. But what you want to do is to reduce the cost of employing those people. And you might want to negotiate reductions in wage cost against a backdrop that if individuals don't accept that, then their employment will be terminated, because it's either everybody or nobody onto the new deal. And in those circumstances, you would need to be looking at collective consultation, because those will be non-fault based dismissals in these circumstances. So, and this has happened over time. We've dealt with a number of exercises of this type where we've had to go through the process, or at least open up the consultation process around the possibility of dismissals where people won't agree to revised and therefore reduced pay package and wage costs from the company's point of view. It's an alternative to a headcount reduction because everybody shares some of the pain rather than only a proportion of the workforce taking all the pain. So that's the theory part about what's a redundancy, and now we're going to move on to look at what we need to do in terms of consultation and process. So the first of these is around the collective piece. Now, for some of you, you'll have been through this a number of times, particularly where you've got recognised trade unions. For others, this may be the first time you've had to think about this. And there are some ground rules we just need to be aware of, because if we don't, it can become very expensive. The reason for that is that under the 1992 legislation, if you get the process wrong, if you don't observe it at all, then there's what's called a protective award. And protective awards are pretty expensive things because it's 13 weeks gross pay per person affected by the process. So it's a quarter of the annual wage cost for the people involved. Now, you might decide, having thought about it, that you're prepared to take that risk. It doesn't invalidate the redundancies. It's awkward, it's embarrassing, it's time consuming and costly, but needs must. You might decide not to go through the consultation process at all on a collective basis, but there is a cost to that. I'll leave you to think about that one yourselves. The other thing to think about is that if we are in a collective process, July and August are, in my experience, absolutely the worst months to try and do this in normal circumstances, because as I'll explain, if you've got lots of people on holiday, it's very difficult to run a compliant process. So we'll come back to that in due course. So there are some things we need to think about here. And the starting point is about numbers, and then we'll talk about some timing issues. So the legislation talks about the numbers of affected people, and that's what triggers whether you have to go into collective consultation. And the important numbers to remember are 19 and 100. So if you've got 19 or less affected employees, that's people who will be made redundant or jobs will change so significantly that you need to consult about it, then there is no collective consultation. And then if it's between 20 and 99, then it's a 30-day period. And if it's 100 or above, then it's a longer period, it's 45 days. It used to be 90. So that's the key in numeric terms. And then you've got to look at this question of an establishment. And this has been the subject of quite a lot of litigation because it's not really well defined or indeed defined at all in the legislation itself. So some of you will remember some years ago now, Woolworths went bust, and that's the authoritative case on this area. Because what they decided there, eventually, having gone through every conceivable layer of the court process, was that an establishment should be equated with basically where someone works. So if I work at a branch of Woolworths, if I work at a particular office of a business or a particular factory unit, particularly that's what my contract says, then that is the establishment to which I'm tagged. And so you then look at how many people at that establishment are affected by the possibility of redundancy. And that's the key. There are some variations, some nuances around that, but they're probably worth discussing more specifically with particular examples. There is some issue around the degree of autonomy that an establishment has from the mothership. So if it's really just a satellite with no autonomy of its own, no control, and indeed hardly any functions other than sitting there doing work, then it may be that that's not a separate establishment. But let's assume for the sake of argument this morning that it is. So having identified how many people are likely to be affected and what our establishment is, we look at the timeline. But I want to talk about the trigger event in all of this, because for some of you, and I say this advisedly, some of you will already have missed the starting gun for this, in my expectation, and indeed based on experience. What do I mean by that? Well, the legislation in the UK talks about the trigger event being when redundancies are proposed. And because all of this derives from some EU legislation, we do need to look at what the EU legislation also says, because it's still relevant. And that talks about when they're being contemplated. Now, if you're contemplating doing something, that normally precedes actually proposing to do it or indeed doing it. So that arises at an earlier stage. But in the UK, it's certainly the case that the accepted definition of what is proposed, and therefore what the trigger event is when you've made a decision which makes these things inevitable. Now, in circumstances around redundancy, if we've got to the position where we have decided in any event we are going to make a headcount reduction, We don't know how many it's going to be, and we don't know specifically the range across all of our operating sites, then we're definitely at the proposed stage, because the decision in principle has already been taken. So if you find yourself in a position where a decision's handed down from head office, and particularly head office abroad, to say you are to do this by the end of August, although we've got more than 30 days from now to do it, the fact is we should start straight away. So you do need to be thinking about that. Other things to think about, and this does affect the timeline as well, are issues around representation. If you've got a recognised trade union, then you have no choice. You have to consult with the union. That's what the legislation provides for. There's actually an advantage in my experience to that, because the unions are definitely more aware than lay elected representatives of what they're meant to do. They understand the process. They probably have their own game plan and approach which they want to take. So in some senses, it's more straightforward. If you need to elect representatives, you need to allow more time, because you've got to ensure that all of those affected have an opportunity to stand, and all of those affected have an opportunity to vote. And many of these people, because of furlough arrangements and the like, may not be in the office. They may not be on email. They may not be as contactable as easily as they would have been in normal circumstances. So you do need to allow more time. And that's why I made the comment earlier about July and August being the worst time of year to be trying to do this. In normal circumstances, it may be, despite the air bridges that have been announced in this last week, that this will be an easier summer to try and do this. That might otherwise have been the case. And you do need to think about the elected representatives. You have very little control over who actually stands or who gets elected. And because it is actually very difficult, because they are acting as representatives for the group, but will also be seen to be there to do the best they possibly can for both sides. They're caught in the middle. They're a bit in no man's land, and they do need some training and support in terms of what they can and must do. And you need to factor that into your Gantt chart when you start planning ahead as to how quickly we can get this done. So quite a lot of work to be done there. And if you're deficient in any part of this process, then the risk of a protective award obviously goes up. And the final point here is about the mandatory elements you've got to cover. The basic purpose of the collective consultation process is to look to see how redundancies can be avoided, reduced, or their impact mitigated, as set out in the legislation. That's your overarching objective. It doesn't mean that they're not going to happen, and it doesn't mean that the process can be blocked in any way, because that's your decision. You can decide how you choose to run your business. But there are some elements that you need to ensure are got across to the elected reps, union or otherwise, and that's about the why, the how many, the selection process, the methodology, the level of redundancy payments, and rather bizarrely, the number of agency workers in the business. That's the whole business, and that has to be set out in writing. The other point to remember is this, that you need to file a form called an HR1 with the Department of Employment, which puts them on notice that a significant number of people are going to come onto the labour market in the short term. If you don't do that, and it needs to be done quite early in the process, actually just before you start giving formal notice to the elected reps or the union, you can be prosecuted and fined heavily for it. And we've seen instances in the last couple of years where that has actually started to happen, probably for the first time really in living memory. So quite a lot of process, quite a lot to think about, some basics when you're trying to work out the numbers involved and the establishments. So we'll move on next to the process of consultation as regards individuals, very familiar, I'm sure, to almost everybody on this call. Let's just have a look at these basic points. The first is the question is, what is the pool from which we're going to take our candidates? The pool plainly on a closure or removal of a particular product is the people involved in it. The pool in relation to the reduction is sometimes more difficult. It's functional, and it is, but indeed, it's something which you can control. You get to decide what the pool is going to be, and provided that you can defend that decision based on reasoned criteria, you will be pretty safe. It's actually very difficult for employees to challenge the pool. But what you need to guard against is taking arbitrary decisions in terms of how the pool has been set. If it looks like you've set it to achieve a certain end, then it's certainly open to challenge. And what I would say, and we'll come back to this again later on, I think, is there's a danger, based on my experience in this sort of furlough period, of people equating those on furlough with the pool for redundancies. And that is dangerous. It's not an absolute prohibition, but I would say guard against it in your thinking and analysis. Second, I'd always with is what are the criteria? Well, nothing's changed here in terms of selection criteria. We're looking at objective criteria, measurable criteria, preferably historic, so not things that we've just had to think of now, which we've had to evidence only based on criteria and figures we brought together recently. So performance, attendance, contribution, those sorts of things. The normal issues here, which we've talked about before on previous webinars, about double counting is very dangerous. So flexibility and breadth of skill set may be the same. They may not, because flexibility may be an attitudinal thing, but the risk of identifying attitudinal criteria is that they're very subjective to the person actually carrying out the assessment. As a word to the wise, I'd suggest you discount absence since 23rd March, simply because many people may have been either on furlough, on some sort of lockdown, and do consider very carefully periods of absence where they relate to individuals who've been self-isolating or shielding members of their family. Assessment and moderation are two sides of the same coin. The key is who's going to carry out the assessment, who's going to score these people, how well do they know them, are they objective, are they independent in their thinking? And moderation is a good idea simply because it's always useful to have somebody else look at the figures just to see if anybody who's done the primary assessment has actually misunderstood, misapplied the criteria, has scored people with a certain either overt or subconscious bias, just to see what patterns are coming out there. I had a case a few years ago where there were two families who worked in the same business, quite a significant business, who were feuding, and the assessment was carried out by a member of one, and lo and behold, all the members of the other family got selected, even though on an objective assessment they shouldn't have been, and that was fortunately picked up in the moderation process. Any selection process like this needs to account for some sort of appeal, so you need to build that in. And there is a legitimate question about when and at what point in the process that appeal would actually take place. Do you allow people to appeal at every stage about being in the pool at all, about the criteria, about the way they've been assessed, or do you leave it all to the end? And the danger actually of leaving it all to the end to a final decision is that by then other people have breathed a huge sigh of relief and assume that they're safe, and you've got to reopen the whole process as far as they're concerned, and clearly that isn't going to go down very well. So mapping the whole thing out, seeing where your pinch points are going to be very important. And the last part of the process with individuals, of course, is that you do have to consider whether you've got suitable alternative employment, and that's not just in the unit they work in, but across the company, and indeed across any associated companies. So when you're looking at this, and this I accept will be difficult in the current circumstances, you need to be thinking about this in the context of, can I show that I actually made those inquiries? Can I produce an audit trail of emails to leaders in other parts of the business, in other areas, that I've got these people with this skill set? Would you need any of them? And it may be, of course, that people wouldn't want those jobs. They may not suit them in terms of location or pay. You're not obliged necessarily to replicate terms and conditions or subsidize a move to another site if you don't want to. So that those alternatives can be made more or less attractive. And just as a final point, if you've got any women on maternity leave who are impacted by this redundancy process, obviously they have particular and enhanced rights, which you don't want to forget, although there's probably a whole other webinar we can do one day on the maternity and parental leave legislation and regulations about the degree of that protection and how that works in practice. Okay, so here endeth the lesson on the theory. Let's look at some of the things which may have changed as a result of COVID and as we come out of the lockdown period. The 4 points on this first slide I would say broadly, and in principle certainly, have not changed at all. We still need to have clarity about our rationale and what we're doing and why we're doing it. But are we thinking about this purely in a sort of an historic 1970s, 1980s mindset about the only way of cutting cost is to cut people? Are we looking at longer term changes in our approach? For instance, would people be amenable to a long-term reduced pattern of working, going on to a 4-day week and achieving that 20% cost reduction as a result? Yeah, it might require more thought and possibly more explanation, but you might be able to keep that skill set, that base of people together in a way that you couldn't before. Let's think as well about what our numbers are going to be. Do we have clarity around that before we start this process? It's absolutely legitimate to work to the letter of the law in terms of what is an establishment, what are our numbers at establishments, and are we going to go for a single exercise, or is this going to be a series of processes over a longer period? And we need clarity as far as possible, and I accept absolutely the world is not perfect in this respect before we start out on all of that. As I've said before, how we meet our collective obligations, I think, is really a significant challenge if we get to that point, simply because of the timing. We're fine where there's the union, you can get in touch with them, you'll know who to speak to. We need to get our HR1 in good time with the greatest degree of clarity we can manage in the circumstances. We need to be thinking about that. Are we yet at the proposed stage? Some of you will be, I think. In terms of the elected reps, I've already talked about how we deal with that around holidays. Do think about how we're going to deal with that communication and what our timeline is going to be. And I realise absolutely that you'll be getting pressure from the business to say how soon and how quickly can we take cost out, because the cash flow is in many respects everything at this point. It's worth thinking about and indeed sourcing some training for the reps, because people, as I've sort of touched on very briefly previously, do have a slightly strange view of what their role is. They are there to represent, they're there to advocate, they're there to negotiate. That may need some guidance, but they may also need to understand that they can't necessarily stop the process, they can simply influence it or try and negotiate and get better terms. So some training in that respect is useful. And what you also need to look at, and this is a challenge particularly in manufacturing, in my view, is how the reps are going to be able to communicate with their constituents. How you're going to cascade that information down to them, where not all of those people will necessarily be on email in the workplace. It's much easier, if you like, in white collar jobs, professional service type environments where everybody's hooked up to their email all the time. So not much there has changed. There are some nuances, particularly about the collective process and getting that timing in place. So if we move on to possible further changes, the sort of redundancy we have, again, there are only, well, there's 3 primary sorts I started out with, but nothing's really changed beyond that. But do think carefully if you want to go for a more nuanced approach in terms of cost reduction by, long-term reduced working hours, so that the no fault dismissal. And if there's always a tendency in those situations, I think, to see whether we can get to an agreement without having the spectre of dismissal sitting behind it. But if ultimately we can't get enough people over the line, and we would dismiss those who refuse to take a reduction in hours and or pay, then it's better to have that out in the open initially, so that we make sure that we de-risk the process as far as we can in terms of collective consultation compliance. How do we consult in furlough is potentially quite complicated because of the communication issue. But what we do know, and what's very clear from the HMRC guidance on this point, is that people being on furlough and in benefit with the job retention scheme does not mean that they cannot be made redundant. In fact, it's very made clear in the guidance that they can. What you do need to think about, almost as an end point, is how you're going to deal with notice in that context. Because if people are employed, even though they're on furlough and not working, you can still claim for them under the job retention scheme. There is an argument or a concern actually, the HMRC will challenge that at some point on the basis that that's patently an abuse. But the guidance does allow it, or it doesn't certainly prohibit it, therefore it allows it, even if it doesn't do so expressly. So do think about that. What you can't do, which you would do in normal circumstances, is say to people, we will pay you in lieu of notice. You can't then claim for them the job retention scheme. So that you would have to self-fund. So you're going to have to take a decision about that. There is an issue about consultation in furlough in terms of how do you do that. Normally you would get people into a meeting room and talk with them, but you might have to do this by correspondence. You might have to get them to come into the workplace or meet with them somewhere. You have to start that process off by letter. I can't contemplate doing a redundancy consultation over the phone, although theoretically it's possible. You could do it over Zoom, because that's the equivalent, or the best equivalent we've got to a face-to-face meeting in the current circumstances. Or you could do it, I suppose, by way of a home visit, although for most of us as employment lawyers, and many of you are in HR professionals, home visits are very dangerous territory indeed in all sorts of respects. They're very invasive. And also you lose, as the employer, control of the environment to some extent. All of those things are going to mean that this takes longer than normal. And you do need to factor that in. So if we're looking at process flow, if we're looking at potential cost savings and realizations, then we're going to have to allow more time before they all arise. Our criteria for selection, I think, are still the same as they were before, subject, as I've mentioned in passing, to discounting absence, certainly for anybody who's been shielding or self-isolating for health reasons, because almost inevitably we then fall into concerns or potential problems around disability. And it's a good idea, I think, to discount that entire period anyway. So finally, before we go on to your questions, a couple of points about furloughed staff selection and predetermination. And I'm speaking in very general terms here. There will be a reason. In an organisation where you have furloughed some but not all people, you will have furloughed me as opposed to Jane for a variety of reasons to do with comparative usefulness, I'm sure. When it comes to the longer term and selection for redundancy, I think there's a risk that you'll simply, or that employers broadly, will assume wrongly that in the long term, simply because I was furloughed, that's still the right decision to make me redundant as opposed to Jane. And that's something you need to guard against, in my view, because if you simply go along with that, you cannot possibly have, you can't show that you've properly exhibited an analysis of our relative merits, not unless you did it on the furlough and wrote it down at the time with suitable selection criteria, scoring and moderation. The final point I want to touch on is this, and this is basically for organisations who have realised in this extraordinary period that they can change the way they do things really very fundamentally. This is not just about cutting down a few people or reducing a few heads. It's actually a whole brave new world. Now, in that situation, we do need to think about what's meant by affected employees, and this is why I raised this issue earlier, one of the reasons for doing it. If we have 100 people in the organisation and we're going to do a combination of things, we are going to take some heads out. We're going to lose 15 people, so no collective consultation, but actually another 35 people's jobs are going to disappear, but 35 new and shiny reconfigured jobs are going to emerge. 50 people are affected by the process, at least 50 people. So we do need to enter into collective consultation to deal with that. And there is case law around that. It's not the net figure, it's the people who are affected by the change. Now, a lot there is going to depend on things we haven't got time to talk about this morning in terms of the extent of change, whether it's 10% or 90% of the job is changing. But certainly you need to look at that. And there was a case reported only last week, in fact, in local government, where an organisation had got that fairly spectacularly wrong because they didn't bother to engage properly and consult with the individuals about how that was going to work. The one advantage that the old role against new role process does have is that where people can apply for new jobs, and you may get a far greater breadth of applicants internally. For the newly configured jobs, it's not quite as hierarchical or progressive in terms of experience because the jobs are going to be different. You can select those you want to appoint as opposed to having to select those you want to leave. And that does give you more flexibility if you go about it in the right way. But you do need to adhere to the process to make it work properly. So that's enough from me. Jane, back to you. Let's see if we can pick up on some of the questions.
Thanks very much, Martin. Yeah, we've had lots of questions coming through, some of which you already covered in the session, so we'll park those ones. There's a couple around the interplay between individual and collective consultation. So it probably makes sense to take those together. One is, in what circumstances is individual consultation alone acceptable, i.e., well, it's phrased as opposed to collective. And does the same trigger for consultation apply if fewer than 20 employees are at risk? So you're in individual consultation territory.
Okay, let's try and bolt those together. So one way of describing collective and individual is that they run in parallel, but that's not entirely right. They're separate processes, but they overlap. So where you've got an obligation to consult collectively, one of the issues you're looking at is selection criteria. So that's got to be established and agreed at a collective level, and then it's implemented at an individual level. There are no redundancy exercises in which individual consultation, you're exempted from it, frankly. It's arguable that if you were doing a complete site closure of a small site with fewer than 20 people, then that would be fine, because what is there to consult about? Well, don't take the risk would be my advice. So there is never a circumstance where individual consultation can be ignored. And collective consultation is not enough, because the fact you've spoken to my union or my elected rep about the process does not mean that I've been engaged in it. You haven't talked to me, you're doing things to me without me from that point of view. So I think that hopefully that explains the first one. The triggers, well, individual consultation is about the fairness of the process. So there aren't absolutes in terms of timelines. There's no minimum consultation period. The tribunal is an example in Birmingham. It's not written down anywhere, but you learn quite quickly. They expect to see it last for 2 or 3 weeks. So they're interested in quantity, not quality. If you got all the meetings done, and they would generally anticipate 3 or 4 meetings in that process, and they want to see that input from the employer's point of view. Cramming them all into 1 week is not going to get the job done properly, and therefore it can be procedurally deficient. So the broad process is going to be an initial meeting to explain what the process is going to be, then a meeting with the individual to explain, well, these are the criteria and this is how we've scored you. The individual gets an opportunity to go away and think about that, come back with alternative points, possibly come back with an alternative idea, challenge that. And at each stage, the employer needs to show that they're actually listening. That's what consultation is. It's a bipartisan process and exchange of views. It doesn't have to act on it, but it's got to show that it's thinking about it. And you can't do that if you bang the process through 1 day, 2 day, 3 day, 4 day, and everybody leaves on Friday. So you do have to be cautious from that point of view. And you know, as a word to the many wise people on this call, experience suggests that if the tribunal want to find fault with what you're doing, they'll find a procedural fault somewhere.
Yeah. And obviously, as you said earlier, in this environment where people are going to have to do it by largely probably by Zoom, WebEx, other platforms are available more than in person, depending on their sector. The whole thing is going to take longer. So there are a couple of questions around the impact of Zoom. One is, which we've just got time to take, I think, before we close. What if somebody refuses to engage in the process and refuses to log on to a Zoom call to be consulted with?
Yeah, well, I think, as with any other refusal to engage in the process, that the refusal can't just be taken as an absolute and at face value. It doesn't excuse you from not trying. You've got to offer them another alternative. There may be a reason why they don't or can't do that. There may be some issue about the tech or the reliability of the tech. You know, we can't just take a knee-jerk view in those situations. And I think people, we've all got very used to using Zoom. I mean, until all this started, I certainly had avoided it, frankly, like the plague. But now I use it all day, every day, and it all seems perfectly natural. But that won't be everybody's experience. And certainly lots of people won't have necessarily the facility to do it at home. So we have to get back to basics and a bit more old school about, can we meet them somewhere? And it's legitimate to invite people back into the workplace, provided we're providing a COVID safe environment if they're not working anyway, and provided we've taken into account their very legitimate and proper concerns about their personal safety, either there or in getting to and from the meeting. Because that's something as an employer we do have to contemplate from an employment perspective, if not from a health and safety perspective.
Great, thanks Martin. So we've come to our full time, so I have to draw it to a close there, and apologies to those of you whose questions we didn't get to. We'll do our best to come back to you separately on those if you've left your contact details. So I hope that was an informative session and helps you in your planning. So just to say thank you very much to Martin for the session and for fielding the questions, and just a reminder and a request to all of you, if you could fill in the feedback questionnaire, which you will get, that will be much appreciated. Otherwise, we will say goodbye and wish you a good rest of the day. Bye.
Bye-bye.